Good day, Crime Talk aficionados. This is Scott Reisch with Crime Talk, and thank you for tuning in. Let's get straight to the docket. First, Letecia Stauch. Her attorneys are treating this case like a death penalty case. What do they know that we don't? Second on the docket, the officers in the George Floyd case go to court and get some big bond set. Third, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. Thanks for watching. This is Crime Talk. My name is Scott Reisch. First, if you have not already done so, we would ask that you please subscribe, hit that like button, and leave us a comment below regarding what we discussed today. First on the docket, Letecia Stauch. For those who aren't familiar with this case, Letecia Stauch is charged with the murder and the tampering with evidence related to the death of 11-year-old Gannon Stauch, her stepson. Well, Miss Stauch has had quite an adventure, to say the least. First, she gets accused of killing her stepson. Then she goes back to South Carolina. And then on the way back to Colorado, she attempts an escape, obviously while in custody. And then Friday, Ms. Stauch was charged with solicitation for escape based upon soliciting another inmate to help her escape from in custody. Sheriffs searched Ms. Stauch's cell and found basically a coded message regarding the Great Escape. She also had a message or a letter to her daughter, which was basically, hey, if you hear that I'm gone, don't worry. Clearly indicating that one could be trying to escape. Clearly shows a little bit of consciousness of guilt. Well, there was a filing today. It's pretty innocuous, but the court had previously ordered that defense counsel respond to the court's order issued on May 19th regarding the defense's inability to conduct a proper investigation. The attorneys for Ms. Stauch state that on May 12th, the defense filed a motion to continue the preliminary hearing scheduled for June 5th. Now, that was scheduled because at the same time new charges were coming down, the issue of competency was raised. Now, competency stays the proceedings until such time as Ms. Stauch can be evaluated by a psychologist. A report will be prepared. And when I say psychologist, I mean potentially a psychiatrist. It depends on whom conducts the interview. A report is prepared. It will go to the prosecution, the defense, and the judge. If everybody agrees to what they find, then either the case proceeds or the case is stayed until one is resumed or one is presumed again to be competent. If one is found to be incompetent, it could take some time for them to be restored to competency if they are, in fact, ever able to do so. Based upon what I've seen, you never know. It's hard based upon the limited interaction that the public has had with Ms. Stauch, but I don't see anything particularly unusual, but the attorneys may have had some interaction that would warrant their concern. So, the preliminary hearing was scheduled for June 5th. That was now delayed. The prosecution had turned over almost 20,000 pages of discovery and 250 items, what refers to as media discovery, videotapes, surveillance, things of that nature. All very time-consuming to go through and watch, I assure you. In the court's order dated May 19th of 2020, the court also states that the defense should be prepared to address the inability to travel to conduct investigation in Colorado and out of state travel due to the stay-at-home orders that are in place not only here but in other jurisdictions, and why electronic means were not able to do so. Public defenders cited the ABA, which is the American Bar Association standards regarding representation. The American Bar Association standards that they provide relate to the representation of a defendant in a death penalty case. The ABA guidelines apply in any circumstance in which a detainee of the government may face a possible death sentence, regardless of whether a formal legal proceeding has been commenced or the prosecution has affirmatively indicated that the death penalty will be sought. Here in the state of Colorado, the prosecution has a certain amount of time, 60 days after the arraignment, to actually state whether they would go for the death penalty. Obviously, Ms. Stauch is charged with 2 counts of murder in the first degree. Both are Class 1 felonies, and child abuse resulting in death, which is a Class 2 felony, tampering with a deceased body, a Class 3 felony, tampering with physical evidence, a Class 6 felony, and 8 crimes of violence, which are sentencing enhancers. The Class 1 felonies include life without parole. It also includes the possibility of death. Defense counsel for Ms. Stauch goes on in their motion to detail the guidelines requiring a defense investigation, and that this should be a mitigation defense almost immediately from the commencement of the case, and that requires in-person interviews. It requires extensive mitigation research regarding medical records, mental health, interviews. It has to be done face-to-face. Now, a lot of people think, oh, why do you just need to, why can't you just pick up the phone, get on a Zoom call? It's not the same thing. When you can go interview a witness and talk about somebody, how they acted, concerns they may have had as it relates to mental health, that doesn't just happen in a quick call. It requires usually numerous interviews, face-to-face, sitting down over a cup of coffee, sitting in the living room talking about their experiences. I've mentioned this in the past. I had a case that was going, as it started out as a death penalty case, and we spent 6 months on the road traveling, conducting mitigation, and ultimately that convinced the district attorney to take the death penalty off the table. Here, the even mere mention of the death penalty makes one think, what has the district attorney told defense counsel about where they think this case may be headed? Simply for the fact that it charges a Class 1 felony, life without parole or possibility of death, in and of itself is not enough basically to warrant an extension of time. However, one could read between the lines here to think that somebody at the district attorney's office may have said or stated that they are contemplating the death penalty. That's the ultimate punishment, and the matter needs to be resolved. Now, although the Colorado legislature here has abolished the death penalty, that doesn't go into effect until July 1st of 2020. Obviously, this took place prior to July 1st, so she would be eligible for the death penalty. Now, we saw in the Watts case, death was taken off the table with a guilty plea straight up to life without parole. And I asked, did he get punked in that regard? Because very few juries here in the state of Colorado have been able to come to a unanimous decision as it relates to imposing the death penalty. In fact, it's frankly very unlikely, and the mere fact that it was revoked or repealed by the state legislature makes it almost nearly impractical that would be the case. However, it's El Paso County. It's a very conservative jurisdiction, and you can't take it off the table until the DA says we're not proceeding with death. Before we get to our next topic, I want to remind you all to go to CrimeTalkSearch.com. There you can sign up for a friend finder subscription where you are able to research individuals' backgrounds, search hundreds of thousands of databases here in the United States. You simply couldn't have the time to do it yourself if you were able to search all these databases that can be done in matters of minutes. It has personally saved me a lot of time, and it has saved my clients a lot of money. I urge you to give it a shot, and if you're not satisfied, you can cancel that subscription at any time. Next on the docket, the officers in the George Floyd case go to court, and they're not happy. Derek Chauvin, he's 44, and he was in court for roughly 11 minutes today. A bond has been set in his case. In fact, it's been increased. It was originally set at $500,000. Now it has been raised to $1 million. The attorney for Mr. Chauvin did not object to the increase, knowing that it was more than likely inevitable, and ultimately his client does get credit while he is in custody. And it's not like Mr. Chauvin probably would feel safe getting out of custody at this point. We know his wife filed for divorce. The police were protecting his house from being basically looted and burned down. He is probably safer and probably acknowledges that he is safer in custody. Mr. Chauvin's next court appearance will be on June 29th at 1:30. Now, where things got a little interesting is it relates to the three other police officers that were on scene that assisted Derek Chauvin and his arrest and knee on the neck of Mr. George Floyd, which ultimately had some impact or some result in Mr. Floyd passing away. So the bonds for ex-officer Thomas Lane, Alexander Koenig, and To Tao appeared in court. Their bonds were set at $1 million, or if they wanted to have pretrial supervision conditions, they would be $750,000. Be surprised if any of them make that bail. All three of those officers turned themselves in immediately upon an arrest warrant being issued for them last week. As a condition of bond, if any of them make bond, they were ordered not to work as security or in any form of law enforcement. They have to surrender any firearms they have, and obviously not to have any contact with any family members of Mr. Floyd. Mr. Tao appeared in the courtroom first, and his attorneys requested that his bail be set at $200,000. The court seemed hard-pressed to come up with any kind of reason or comparison as it relates to other cases and denied that request, and as we stated, $1 million or $750,000 with conditions. Mr. Koenig appeared next in court, and his lawyer, Mr. Thomas Plunkett, argued that George Floyd's death occurred during Koenig's third shift as a police officer. Can you imagine? Third day at work and you're charged with murder? Now, he asked for leniency and also asked that his client's bond be set at $200,000, which was rejected by the court. Mr. Thomas Lane then appeared, and his attorney, Earl Gray, argued that the case against his client was in fact quite weak and stated that it was his client that stated he should in fact roll Mr. Floyd over, and even questioned what was taking place at the time, and told the court to ask yourself, where is the intent of any kind or aiding and abetting at all? It was also highlighted by Mr. Gray that his client, Mr. Lane, had only been a police officer for 4 days. 4 days. And since he was a police officer for only 4 days, and that Chauvin was basically the training officer on scene, who do you think should be held responsible? Are they all responsible? Were they just doing what they were told? You know, it sounds like Lane at least tried. You can hear it on the video where someone says, should we roll him over? And Chauvin, in fact, basically tells him no and continues to put his knee into Mr. Floyd's neck. That is where this case was going to get very, very interesting. I think Chauvin has got some real problems. The defense for the other three officers, you know, you got Mr. Tao, who's basically standing there. The other two officers kind of doing what they're told. Not a great defense, but a jury may consider that for mitigation purposes. And certainly it's something that a court would have to consider if these three are ultimately convicted. But under the law of complicity, if you aid, assist somebody in doing something, even if you're not absolutely sure what the results are going to be and how they're going to turn out, you can be found guilty just like you did it yourself. It's going to be an interesting case, and obviously it's changed lots of people's minds. There's already a movement to defund police departments in Minneapolis and other areas across the country. Really, I think defunding is restructuring. Police officers are not going away. Could you imagine, there's a horrific crime next door. You just call your neighbor, you call the social worker up and say, please come help me. That's not going to happen. And I think once the hype wears off of everything regarding this, calmer heads will in fact prevail. And there'll be lots of restructuring, maybe demilitarizing police departments, but I don't see police departments going away anytime soon. Next on the docket, our dumb criminal contestant of the day. And yes, who won the dumb criminal contestant of the week last week? Yes, take a quick look. Mr. ATM man leaving the riots with an ATM trying to get it on the bus. He's our winner. He deserves it. He may be in the contestant for the dumb criminal contestant of the year. So hats off to him. If anybody knows who he is, let him know. Send us an email, call us. We will get him his mug. Our dumb criminal contestant of the day comes from Wisconsin. And our dumb criminal is Mark Allen Johnson. He's 67. Now, I want to make it very clear that we are not calling our contestant today a dumb criminal because obviously he has a severe alcohol problem. What he's dumb about is he is the ultimate high rep learner when it comes to the fact that you can drink as much as you want, but you can't get in a car and drive somewhere. Mr. Johnson was sentenced the other day to 4 years in prison because it was his 15th alcohol-related offense. That's right, 15th alcohol-related offense. Now, Mr. Johnson's attorney says, well, it was really only 9, so therefore that's okay. And he described him as a nice, down-to-earth man who obviously has a drinking problem, but he shouldn't deserve to go to prison. The court stated otherwise. And like I said, we, as someone who has dealt with individuals who have had drug and alcohol addictions, we certainly understand how difficult that can be to overcome. And there'll be no one that says you can do whatever you want to your own body, but the law is there to protect you from harming these other individuals. If you get in a car like Mr. Johnson did and pull your car into an intersection and ultimately into a ditch when you're drunk, you create a risk of killing someone else. So, Mr. Johnson is our dumb criminal contestant of the day, and hopefully there will not be a number 16 for alcohol-related offenses. That's what we have for the docket today. We want to thank everybody. We do appreciate you taking the time. We know there's lots of things that you could be doing, and the fact that you take time from your busy schedule, from your families to watch Crime Talk is not unappreciated. We appreciate you. And for those who would like more basically one-on-one time, you can always go to Patreon, sign up. Last week after our live, we had a Patreon session. I think we had maybe 15 people on there versus the 800. So it's a lot easier to answer questions, and we kind of stay on while we have anybody there. If you'd like to do that, hit the link. If you'd like to get the Crime Talk gear without having to be a dumb criminal contestant, hit the link below. Order the t-shirts, the mugs. You won't go wrong. And as always, support our sponsors that support us. Go to crimetalksearch.com, sign up for People Finder, and sign up for that subscription. Thank you. Have a great day. We'll talk to you tomorrow on Crime Talk.